But don't worry if it doesn't come up, because we're not going to be making a lot of noise and commenting in between, interrupting.
Okay, we're going live. Good evening and welcome. This evening we are happy to host our third online workshop, which encompasses the very important topic, understanding legal fundamentals when caring for the elderly. This workshop will cover the elements encompassing a few of the overall legal aspects when caring for the aged or living with an elderly parent. During the workshop, you will also receive practical steps in dealing with various situations or possible case scenarios. I'd like to take a moment now to welcome our speakers. Melody Zeervogel, our clinical specialist.
Welcome to the Villa, specialized upmarket dementia care facility. The Villa is situated on Nazareth House's secure property in the peaceful neighborhood of Vredehoek, overlooking the picturesque Table Mountain and Lion's Head. Our goal is to provide specialized dementia care in a home-like environment.
John is in a private practice as an attorney and mediator based in Cape Town. He specializes in mediation.
We understand it's a difficult decision to move your loved one into a care home. You can be assured that our staff are welcoming and supportive, and their goal is to make the residents feel safe and at home. Our care team is dedicated to assist with all the basic care needs, physical comfort, emotional well-being, and spiritual needs. We provide 24-hour dedicated dementia care by trained care providers.
He also has a book called My Mediation in the Family.
Our registered nurses, present day and night, monitor the well-being of the residents, ready to assist with medication and treatment. We have the option of a fully furnished single room with ensuite, or furnish the room yourself with the furniture familiar to your loved ones. The villa is surrounded by a garden, where our residents come in contact with nature. Tranquil walks and afternoon tea are amongst the favorites. We not only provide physical care, we look after our resident well-being by arranging stimulating activities such as coloring, music classes, and animal therapy. Our spacious living areas provide residents with the opportunity to connect with each other and share stories. Our core values are love, compassion, respect, patience, justice, and hospitality. We would love to Welcome to the Villa, specialized upmarket dementia care facility. The Villa is situated on Nazareth House's secure property in the peaceful neighborhood of Vredehoek, overlooking the picturesque Table Mountain, specialized upmarket dementia care facility. Our goal is to provide specialized dementia care in a home-like environment. We understand it's a difficult decision to move your loved one into a care home. You can be assured that our staff are welcoming and supportive, and their goal is to make the residents feel safe and at home. Our care team is dedicated to assist with all the basic care needs, physical comfort, emotional well-being, and spiritual needs. We provide 24-hour dedicated dementia care by trained care providers. Our registered nurses, present day and night, monitor the well-being of the residents, ready to assist with medication and treatment. We have the option of a fully furnished single room with ensuite, or furnish the room yourself with the furniture familiar to your loved ones. The villa is surrounded by a garden, where our residents come in contact with nature. Tranquil walks and afternoon tea are amongst the favorites. We not only provide physical care, we look after our resident well-being by arranging stimulating activities such as coloring, music classes, and animal therapy. Our spacious living areas provide residents with the opportunity to connect with each other and share stories. Our core values are love, compassion, respect, patience, justice, and hospitality. We would love to extend our warm welcome to the member of your family in our home-like environment, where they can feel safe, loved, and well taken care of. Call Nazareth House today to secure a spot in this upmarket dementia care facility in Cape Town.
Okay, welcome back. All right, so we'll give a warm welcome to everybody. You guys can give a wave. Hi. And if you can switch your mics on, we will then just approach the very first topic here this evening. And it is power of attorney when dealing with the elderly. All right.
Great.
Quite a
So,
big topic.
absolutely. Thanks very much, and good evening, everybody. And Gunnar and I are going to approach these topics in a fairly conversational way, so each of us will chip in. But maybe just to kick off on powers of attorney, a couple of basic things to understand are that it's a document. It's a document in which you give powers to somebody to do things on your behalf. And although it's called a power of attorney, that person doesn't have to be a practicing or qualified attorney. It has to be somebody that you trust is capable of doing the things you need them to do for you, whether that's shopping or going to post offices or doing various things around and about town, tasks of daily life that you yourself might not be able to get around town so easily to do. Maybe the most important first concept to understand is that it's a document in which you give powers to that person which have to be things that you yourself can do. So if you lose mental capacity or become incapable of acting on your own behalf, the power of attorney, strictly speaking, lapses at that point when you can no longer give powers to other people. And that's often not understood, that a power of attorney doesn't endure beyond your own capacity to do things. It endures for as long as you are of sound mind, able to give instructions, but it is for some or other reason not practical for you to go to the post office or go to the shops or whatever it is you need somebody to do. So that at the very basic initial level, it's a document that has to be signed by you as the person giving the power, and it is also a good idea to include a specimen signature of the person who is receiving the power on that document, so that whoever in an institution is looking at it can see what the signature of the person who's been given the power looks like. Mm-hmm. But there you start coming up against some practical challenges straight away. And Gunnar will say a little bit about what can happen if you take a power of attorney into a bank, for example. And you've signed a nice power of attorney with your attorney, and it looks very nice, and it's got all the signatures on it, and 3 pages of detailed powers that you've been given, and you march into the bank and say, I'd like to close this account, please. Bruno, maybe you can just talk a bit about what can happen there.
Yes, well, I think the bank is going to say, no, we won't. We won't act in terms of the power of attorney. And that has changed probably over the last 10 or 15 years. So oddly enough, about 20 years ago, you would have been able to go to the bank with a power of attorney signed at home in favor, say, of your son or your daughter, and your daughter would then go to the bank and saying, I've got a power of attorney, here it is. Would you please transfer funds to my account or this account or close this account or do whatever? That, of course, lends itself to fraud. And with the prevalence of fraud that we have these days, banks will no longer accept a power of attorney unless it is signed at the bank in the presence of a bank official. And there are slight differences from bank to bank, but what is generally required, and you can make inquiries at your own bank, is that both the person wanting to give a power of attorney and the person in whose favor you want to give the power of attorney must be at the bank and sign the documentation in the presence of a bank official. More often than not, they prepare bank documents that you need to sign. So it's absolutely really pointless trying to sign a power of attorney and then going to the bank with it. Find out what your bank requires. You won't have to arrive with documentation. The important thing is both of you should be there. And the one party says, look, I'd like to give the power to the other party to operate on my account or accounts. And they will prepare documentation at the bank, which must then be signed at the bank. And they'll require a specimen signature, these days even fingerprint sometimes, of the person to whom the power of attorney has been given. But
so what happens if the person is physically incapable, for example, frail, in bed or in a wheelchair, and they cannot go there? Will the bank accept, maybe send someone out to the person, or is there any other way around it?
That is a good question. That really depends on the bank. If you have been a valuable client and you have sufficient funds and you have a private banker, they will more often than not make an arrangement.
Okay.
It really depends on the bank and the relationship you have with your bank and the number of years you've been with them. And I'm sad to say, probably the amount of money at the bank.
Yes.
So they may or may not. But in my experience, it's really the important thing to consider is that the fact that you walk into a bank with a power of attorney is simply not going to work. From a practical arrangement, contact your bank if this is something that you want to do and see what they can do for you.
Okay.
Yeah.
Perhaps just on the other aspect that John mentioned, the fact that you can't give away more power than you yourself have. So when you become incapacitated, your power of attorney, strictly speaking, becomes invalid. There is a concept of an enduring power of attorney that operates in many other countries. So in most European countries, I think also in the UK, you can give a power of attorney and make it a power of attorney that endures beyond your own incapacity. In some countries, you can even have a power of attorney that endures beyond your own death, so that people can deal with bank accounts, etc., after you have died. The South African Law Commission has made recommendations, I think in 2001 or 2004. They've even published a bill. It's a very sensible arrangement to have in place because, and we'll deal with it, I presume, a little later, the whole questions of curatorships could possibly be avoided, where you can give a power of attorney while you still are capable in favor of somebody you trust, and it endures beyond your own incapacity. I'm afraid it's been lying in some parliamentary drawer for the last 15 or 20 years and hasn't been looked at. That's sad, but we don't know whether it will be looked at and when.
I don't know if we're going to later on. Sorry. Who makes the decision that?
I think we might have lost Letitia there briefly.
Frozen.
Melody, go ahead.
I was going to ask, how does a power of attorney work when it comes to making medical decisions and like medical proxy decisions and things like that? For example, whether to hospitalize somebody or whether not to, or whether to resuscitate somebody or whether not to. How would it work then?
I'll come back, Letitia.
Thank you. I don't know what's happening with my team.
Yes.
So you do have different types of powers of attorney, and you also have a document called a living will. So to just separate out the issues that you mentioned a little bit, the resuscitation issue will generally have to be covered by a living will. And with this, one must check the wording very carefully, and it is a good idea to speak to an experienced attorney about the wording of a living will, because doctors and medical staff and nursing sisters obviously, when they are presented with a living will, need to look at it very carefully and make quite sure that its terms do cover issues of life support and resuscitation and, terminal treatment and things like that. So living will is important to think about, as is doing an ordinary will. Doesn't really specifically come under the topics right now. We'll talk about it later on. But it's very important to think about those documents and powers of attorney. Just quickly on the question of different types of powers of attorney, what we've been talking about up to now is what we commonly call a general power of attorney, which sets out quite a bit of detail, a whole variety of legal steps that a person can take. Some transactions require a special power of attorney, for example, property transactions, and that's it's quite clear from the documents. It's usually called a special power of attorney, and it relates to a specific transaction like cancelling a bond or something like that. But what we're talking about tonight is primarily general powers of attorney.
Great. So let's move on to the next question. Then, when is the right time to implement power of attorney?
As early as possible, I think. It's a good idea just to think about a power of attorney at the same time you do wills. Just anticipate that things could happen and that you might need somebody to do things on your behalf. So I always recommend that people do it. Quite often you have young clients who travel a lot for work. It's got nothing to do with health or mental health, but they might just be in Zambia or anywhere and unable to attend to a landlord who's giving some trouble to a tenant. And then if you have a power of attorney given to somebody that you trust, then it can just save a whole lot of problems. So, I think the simple rule there is as soon as you think of it and the sooner it's happened.
I think what we found is many times families are feeling guilty of taking away the power or the control of their parents or the family member, and then they typically delay it too long. Often it's too late then. By the time it comes, they didn't have to go for curatorship because power of attorney is no longer possible. So we're trying to get the message over, like you say, as soon as possible. It's not a matter of taking over. It's just a matter of making sure things run smoothly when things are no longer able to be done.
Yeah, exactly. And also maybe just useful to mention at this point, you don't only have to appoint one person or give one person power of attorney. You can give a power of attorney to several different people with exactly the same powers. So, it can, in a family, no pun intended, can feel like a bit of a power struggle, but it doesn't have to be that. If you've got 3 children, you can give all 3 of them power of attorney. As long as you're comfortable to do that and trust them all and they trust each other, then that should be fine.
All right. Should we move on to the next question? All right. It's curatorship and estate management for the elderly.
Okay. So what happens is, of course, is that many elderly people simply become incapable of managing their own affairs. When they've reached a stage where they are incapable, not due to some physical defect, being in a wheelchair, etc., but due to mental incapacity, and they cannot deal with their own affairs anymore, then and this ties in with what I said earlier, but the fact that we don't have an enduring power of attorney, strictly speaking, a power of attorney then comes to an end. And so you have that situation, or you have the situation where somebody in any event never gave somebody else a power of attorney. And now somebody needs to make decisions, financial decisions on their behalf. That is where a curatorship application comes into play. A curatorship application is an application to court in terms of which a curator is appointed, or where you ask the court to appoint a curator. It's called a curator bonus in general terms, to manage and we refer to them as a patient's affairs. It's a application that has obviously major consequences for a patient. So it's an application that's done with lots of checks and balances. It's an application that has to be done to court. It has to be supported by affidavits, by family members or an applicant who knows the details. All sorts of details need to be set out on the application. It needs to be supported by supporting affidavits from 2 medical practitioners, one of whom must generally be a specialist psychiatrist or somebody. And even then, the court, based on that, will not immediately appoint a curator bonus. But what happens is that there's an interim court application where a curator ad litem is appointed. The curator ad litem is somebody that is generally a lawyer, more often than not an advocate, who will then do a separate investigation and report back to the court on whether it is sensible to appoint a curator bonus. So the curator ad litem he will interview the patient, he will interview the patient's family, he will interview the medical practitioners, and then does a very detailed report which goes into the court file. And when the matter next is on the court roll, is going to be looked at by the judge. And it's on, if the curator ad litem confirms that it is necessary to appoint a curator, the court then makes an order. And then that order is lodged at the master's office, and the master of the High Court then issues letters of curatorship. So that's the basic procedure.
Ghana, what happens in the meantime, in that interim period, when there's no person appointed? Does the curator ad litem have the capacity to make decisions, or is everything just in limbo until the court has appointed someone?
It is really in limbo, I'm afraid. Yeah, the curator ad litem cannot make decisions. A curator ad litem is a person that is always an essential part of any curatorship application, but you get curators ad litems in all sorts of other scenarios as well. John, for example, if you were to litigate on behalf of a minor or or in some other capacity where the person doesn't have full contractual capacity, then an advocate is usually appointed to look after his or her interests in the court proceedings.
Just operationally, if I can speak of our experience in the villa, is when it's that limbo period where you need the most support, and that's where we need the most help. So oftentimes when it comes to medical care and things like that, we're solely, the onus is on us to make the call, and that can be a bit stressful. So it's just important to give the public out there just an idea of how long this process can take, because it's literally stuck in the court system, and all we can do is rely on other laws like governing the elderly and the Elderly Abuse Act and things like that to safeguard them and make the best medical decision we can make. And that we do with just looking at the resident and the needs they have and making the best call possible, and consulting the multidisciplinary team, getting together, making the best call, presenting that to the future curatorship firm, and just doing our best for the resident while we're in that limbo period. So that's what we do. It's a great responsibility, but we all know that curatorship takes a long time. But in the end, it's worthwhile, especially for those residents that don't have family or other means of support while in the limbo period. Yeah.
Dana, you'll be aware we have one of your clients is in the villa with us, and unfortunately the curator ad litem was also appointed in the lockdown period. So this was quite frustrating few months because nothing could be done, and we had to really deal with everything, like Melody said, as best we can. So I can imagine it can be frustrating for people to be in this process.
Yeah.
Okay, so yes, go ahead.
The time that it takes for a curatorship application is generally, more often than not, and sometimes you of course have difficult ones. You have disputes in the family. You'll have children who want a curator appointed, and other children who think it's not necessary. Correct. Often there'll be a child that is effectively in control of the parent because he or she may live with the parent, and there's there's other children who may be overseas who think there's something funny going on and they want a curator appointed. And of course, you have these sort of litigious situations, in which case a curatorship application can be quite difficult and time consuming. Where there is where none of these issues arise, a curatorship application can generally be, from start to finish, can be done in about 6 to 8 weeks.
Okay.
It has, of course, as you mentioned, it's been a little different this year. We've had difficulties with our courts, and they've been closed, and it's been difficult for curator teams to go and interview patients. So perhaps it's taking a little longer, but it can be done in an ideal scenario, 6 to 8 weeks.
I don't know if we're going to talk about this, but the financial implications of appointing a curator, it's some costs involved. I don't know if some families might be scared of the additional costs. Could you maybe just shed some light on that?
Yeah. John, do you want to go? Or?
Okay, I'll speak a bit about that. Yes, I mean, clearly there is a cost implication, both in terms of bringing the court applications, and these obviously vary, but it can be an expensive exercise. There's a Department of Justice document on these applications which talks about as an average between 40 and 60,000 rand to get applications done, and it varies enormously, but it can be expensive. And then, of course, there is also a ongoing cost, which is a prescribed rate based on the annual income of the estate that's under curatorship. So there are costs involved. There is a procedure in terms of Section 60 of the Mental Health Act, which is similar to the appointment of a curator. It talks about the appointment of an administrator. It's a slightly simpler procedure than the curatorship, but it is a relatively untested area as to whether institutions will happily deal with somebody who comes and says they're appointed as an administrator under the Mental Health Act, and might then turn around and say, no, well, actually, we want to see a curator's appointment. But there is a procedure which could work certainly for poorer clients or clients who have no money, relatively straightforward, and it gives the administrator the powers to manage the person's affairs, and it is also administered by the Master of the High Court. So those things should work, but as I say, there are going to be situations where people will want to see a curator's appointment in any event. So yeah, clients, there are costs, no money, relatively straightforward.
I think if you consider all the work you guys do and all the nitty-gritty and the legal things, the knowledge and the background, it's very well worth it. If this person with no knowledge would try to do it themselves, it would take much longer and probably be a lot more complicated. So it's definitely worthwhile to appoint that curator.
Yes. And sometimes it's unavoidable. It just sometimes has to be done. Yeah.
Is there a difference between a guardian and a curator?
Yes, so a guardian is a person appointed to look after the affairs of a minor, which in South African law is a person under 18 years old. And a guardian will be appointed either in terms of a will or again by the Master's Office, but it relates specifically to minors. Crops up relatively rarely because both natural parents remain guardians unless the court deprives them of guardianship, which is very rare. So even if one parent dies, the other parent remains the guardian. So it only really becomes an issue when both parents die before the child reaches the age of 18, in which case a guardian is often nominated in a will but still has to be appointed by the Master's Office.
Okay.
And curatorships will be a different issue, as Gunnar described. Curator would be appointed by the court to manage the affairs of somebody who cannot manage their own affairs.
Yes.
It might just be for people that haven't had much experience. A curator is very, very strictly controlled. A curator who's appointed by the court and then receives his letters of authority from the master's office needs to submit a very detailed account about all of the income and every conceivable expense. So it's very tightly controlled. So family members, should feel very comfortable if an attorney, for example, is appointed as a curator to their parent and who's going to look after the parent's financial affairs. The chances of there being mismanagement or overpayment or undue payments made by a curator, it's very slim by virtue of this control and by virtue of the fact that the curator has to submit an annual account to the master, which needs to be supported in huge detail and not only that, but a curator, before he spends the patient's money in any sense, needs to continuously get approval from the master of the High Court. So if the patient, in theory, needs new pajamas, you need to write to the master, get a quote from Woolworths, write to the master saying the patient needs new pajamas. This is the reason. This is a quote. May I buy new pajamas for the patient? That's how it works. So it's controlled, and it's a system that works well in practice.
I just want to add to what you just said there. If I look at operationally, what we do in the villa when we work with several curators is exactly what you're just saying. It's from when a resident moves in, it's from asset control, what comes into the building, furniture-wise, stock control-wise is very strictly controlled. So we want to look at all consumables, how much they cost a month, and then we do comparative reports from month to month, because all of this information goes to the curators. And some curators want information yearly and some want it quarterly. So we keep very strict control of how much money is spent with regards to toiletries, incontinence wear, everything like that, because we have to give account to it. And then the same as if a resident passes away as well, is what the resident came in with versus what's left in the room, and we have to account for that. So I just want to agree with you. It's very strict control with regards to residents' belongings and stock control, and everything that we want to spend has to go through a communication channel. So yeah, just wanted to back you up with what you said. And we account, and I know for myself, you spend a lot of hours just writing down in order for us to help you with regards to stock and quantities and amounts of money. Yeah.
I would imagine operationally, just a simple bit of advice that would be useful is whether one's working in the sphere of a power of attorney or curatorships or administrators, is just to have a team of people around you if you are moving into a place like the villa, and have a list of contact numbers and email addresses of people that it would be useful for somebody to speak to if there's suddenly a problem. If you're suddenly taken into hospital, that there's an accessible list that the villa has got, and that your person who you've given power of attorney to has got contact numbers, bank account numbers, because it's amazing the number of people who you suddenly have to help, where you really just have no clue where to start finding out what's what and what needs to be arranged. And weeks later, you hear about a car that's parked in somewhere and hasn't been retrieved, and all those kind of things. So just that sort of folder of contact numbers and useful information is really well worth doing. And I know we all put it off and don't want to do it, and it's a nuisance, but it really is a useful thing to do.
Great. No, thank you for that.
Okay.
We spoke about the different types of curators. We've touched on curator bonus and ad litem. What about ad persona? Can you tell us a bit more about those different types of curators?
Okay, John, do you want to go or shall?
All right, I'll talk about curators ad personam. So there are differences in the types of appointment. Curator, a person who is appointed as a curator to the person, is it's a more extreme form of curatorship, if you like, from the curator bonis. Curator bonis means the curator of the goods of the person. So the person who is appointed as curator to manage your basically financial affairs and property affairs. Curator ad personam ventures closer into the area that Melody was asking about earlier on, where the curator might be appointed to make decisions about medical treatment, for example, for somebody, or where they are going to be housed, if they're going to be moved, out of a different place of residence, things like that. The more kind of, let's call them personal decisions. There are certain status decisions that no curator can ever make. So a curator can't decide, for example, that the person they have under curatorship ad personam must now get divorced from the person they've been married to for 35 years. Curator can never do that. But many other decisions about movement, residence, transactions, those kind of things, the curator ad personam can do. But the kind of curatorship Bruno was talking about earlier on is generally what we talk about is a curator bonus. Somebody who manages the goods and finances and property. Am I right, Gunnar, that it's quite rare to have a curator ad personam?
Yeah, it's quite an exceptional thing, because a curator ad personam really takes away. But one thing one must appreciate, and that perhaps is not generally appreciated, is that a curator bonus is appointed to assist a patient in managing the financial affairs of the patient. It does, contrary to popular belief, actually not take away the rights of the patient to manage his or her own affairs. It doesn't stop a patient when he or she might have a lucid moment to enter into some transaction and to go and purchase something, or to take a loan, or to do. A curator bonus is able to assist and open a bank account and deal with the finances, etc., but it doesn't actually, strictly speaking, take away the rights of the patient, because you do have got patients that have good and bad days. I'm a curator bonus, for example, to a relatively young woman that has had huge addiction problems and had to give up her job to go and spend months in an addiction clinic. She has largely recovered and is able, while I'm still assisting her with financial decisions, she can go to work and she can do things, she can enter into transactions. A curator ad personam is a far more radical thing. That really divests the patient of nearly everything: where to live, when to have an operation, when to have a tooth taken out or not. And as you said, the possibly the only two things that a curator bonus cannot do is he or she can't do a will on behalf of the patient, and he can't get a patient divorced. Although we've managed even that, I've got to tell you, by getting a special court order authorizing the curator to institute divorce proceedings against a really evil spouse.
Okay. We have a lady in the villa that has no family, no children, nobody. She's on her own, and she's obviously one of your clients, and she has obviously got a curator bonus. I assume then you are also then her curator ad personam, because there's nobody else to make those decisions for her. Huh?
Yes, you've always got to, when you're bringing a curatorship application, you've got to make a decision. When you take instructions from the family and the clients, and very often from an institution such as yours. We've got a patient, there's no family. This is the scenario. You've got to then make a decision as to whether you go and ask for an application, ask for a curator ad personam and a curator bonus, or only the curator bonus. As I said, the curator ad litem will always make a recommendation, and they're far more fussy, and it's far more difficult to get a curator ad personam. It's considered to be a very, very radical step.
Okay. Because when she arrived with us, she was mentally fine. Then we discovered she had Alzheimer's disease. So I think that's when the decisions were made. So there's nobody else who could make those decisions for her. So that was quite a complicated situation. I think it's a very sad situation. You would have then had to take decisions on behalf of her.
Yeah. So then what would happen is like you said, Gunnar, the curator at Lightem came through to us, to Nazareth House, and then they would interview me or have a look at the facility and have a walk around at where she was going to stay, because then the curator bonus would be in charge of accommodation and fees, that kind of thing. And then also we have to submit a report and submit things like best practice, how we would care for such a person, and all of that goes to court, and then they make a decision on how best to help the residents. So they really try and get as much information as possible in order to make the correct informed decision, which goes to court. And then, and as I said, and when you're in the limbo moment, if something happens, if a resident falls or needs surgery or that kind of thing, then we would know to contact curator bonus, whether it's for someone with mental incapacity or someone that isn't and has a curator, just to help with finances like admission costs, that kind of thing, to cover cost of care. And then if there's no one to make a decision and the client is, say, for example, unconscious on the floor, we need to know who to contact to help us make an informed medical decision. Do we take the person to hospital, or is it palliative care or comfort care or upping levels of care? That's where we would contact the curator ad persona. Yeah. And while we're in the limbo period, we would take those decisions on us with the multidisciplinary team and just submit all that documentation to the curators just to back us up. That's how we handle it at the moment.
Okay, so we can now go to a quick slideshow on our Nazareth Care Center, and then we'll be back. Wonderful. Welcome back, everybody. So we've touched on, in fact, not touched, we've gone right through topic 4, which we've done all the definitions as such, curatorship. We'll then go now to topic number 5. And that is over here. Let me 1 second. Dealing with curators and finances from a facilities point of view.
So some of these things we have talked about already in a way, but a couple of things just come to mind that might be worth mentioning. In the modern era of internet banking, obviously a lot of patients and residents will have internet banking, and some do, some don't, but certainly some quite elderly are quite comfortable doing internet banking. And obviously there the question of trust, if they give any kind of access to internet banking to the person they give power of attorney to, you just need to be very careful about that. It obviously makes life a great deal simpler if you do give somebody that you do trust access to that kind of thing. But if you do that, obviously the checks and balances need to be very carefully in place. So some kind of arrangement about regular reporting and copies of bank statements printed out and delivered and that kind of thing is a good idea. And it comes back to what I was saying earlier on about teamwork, that if you do give somebody that kind of access, it's a good idea that somebody else knows what's going on and also has, is in the loop and knows how to get involved if something needs to be done. We've got one patient who, one person does the grocery shopping, another person does the banking, another person does running around and collecting parcels, and there's a team of 5 or 6 friends who help with day-to-day things. But I just mentioned that internet banking thing is something to be careful about. It can make life a huge deal simpler. I had an example where after about an hour and a half speaking to banks about the very powers of attorney and documents that we started the evening talking about, and then eventually the person in the bank asked, well, does the patient have internet banking? Yes, she does. Oh, well, fine. Then this is what you've got to do, and this is what you've got to look for on the website, and there you go. If we started the session with that conversation in the bank, it would have taken 5 minutes instead of an hour and a half. But obviously, it's something one must be very careful of, and trust is the absolute there. And if you're at all uncertain whether the person is trustworthy, then don't do it. But it increasingly is going to be an issue in the future.
I also find, from an operational point of view, if I look at the villa and also some of the other elderly that we live amongst and work with, is that there's also a play upon Mental Health Act in one hand, and then you've got the elderly, the rights of the elderly in the other act. So say in your other hand, so say for example, someone moves in with you, but they're mentally incapacitated, but you look at it from a quality of life point of view and you want to keep them as, try and help them be autonomous, and you try and help them move forward and gain as much dignity and right as they can. Like, you kind of feel conflicted. Like, do you take their bank cards and their ID and all of that away from them when they move in, or do you let them keep it? Like, you're faced with decisions like that, and then you have family that come and visit, and you don't know the family dynamics, so you're still getting to know this person and the family dynamics, and then all of a sudden they want the person's cell phone, bank cards, and you're stuck with this dilemma, and you go, do I give it or do I not? And then I always say to myself, you know what? You're like the adopted mother of this person and you're safeguarding them. So I just hang on to it until I know the information and I don't give it out. But you often have these conflicting situations because they come in with a lot of valuables and decisions, and you don't want them to be abused, because unfortunately there are a lot of people out there that are call them predators or opportunists that do take advantage of the elderly, and it's my job to protect them. So at the end of the day, the onus is on me as to how I protect the person. So you're often faced with these ethical dilemmas, which can make things a bit difficult. And it's not just one person; it's like a whole estate.
Yeah.
Yeah, I think you make some very, very good points there. The two issues come to mind. The one is family dynamics. Those can be, when it comes to the elderly, those can be very, very difficult to handle from time to time. What happens more and more frequently is that an elderly parent that might reside with you, for example, will have 2 or 3 children, and more often than not, a majority will be overseas these days. They will have emigrated at some stage and will be in Australia or New Zealand or in England, and very often you're left with one child who is here. and who is effectively then in control and might have the internet banking access for the parent and deals with the parent's finances. And it is unbelievable how quickly that can create mistrust between siblings. Because you'll find that the overseas siblings who are not really in a position to help because they're far away start thinking about the local child who's assisting the parent. Is some of the money possibly going into the wrong pocket? These issues we deal with on a very, very frequent basis. The simple recommendation is, if you are in effective control of elderly parents' finances, and of course this amounts to a bit of an informal curatorship, because very often you have a child really acting as a sort of curator to a parent without there having been a proper curatorship application. And provided that the child does so honestly and keeps a meticulous record of what has been spent, it's often not a problem. I think the most important thing is keep a spreadsheet. If you find yourself in that position as a child, keep a spreadsheet. Make sure that every expense, every amount withdrawn from your parents' account, every expense is vouched for, that you've got a good, because it creates, more often than not, after the death of the parent, it can create enormous difficulties between siblings that until then may have gotten on very well.
Sure. I agree. That's very difficult.
Awesome.
And the other thing that you've just mentioned is that I'm afraid you mentioned sort of abuse of the elderly and people taking advantage of. There is, I think, I'm afraid, a horrific amount of that going on. Elderly are very often find it very difficult to say no. They may have been living at home with carers by the time we become involved as curators, because when finally a family member has found out that the parent's bank account has been decreasing at a very, very rapid rate, you'll find that the carers have taken money, that there've been loans to carers and loans to carers' friends. And I was involved in the curatorship of a man who lived in Langebaan, and he had lost his mental capacity over a prolonged period and went on gradually. He had given away most of his fortune, and it was largely to the local police force in terms of so-called loans. And every policeman in Langebaan for a while, well, not everyone, had arrived at his house to take a loan. And he had a little black book, but of course there was no real prospect of any of this ever being repaid. And by the time the family found out about it, it was rather too late to try and do anything about it. So the abuse that goes on can be very serious, and if in doubt, and particularly if it's in a state where the, say, 50,000 rand required to bring a curatorship application can be justified, rather do it than wait.
And I think it's, sorry, Letitia. No, you can go first.
I think it's important for families also to realize here that when you see your parent is aging and you realize there's deterioration taking place, even though it's nothing, maybe investigate early enough and get that power of attorney in place or whatever is necessary, so to try to prevent the abuse that could happen when some people, like the police force, try to abuse the person. Melody, you want to say?
I was going to say another dilemma I'm faced with at the villa as well is you're in charge of this person now because they've moved into our unit and you're sort of their custodian, and on admitting the person that there's no power of attorney and no curator, but they're mentally incapacitated, and now you know their mental scoring and their medical history and the exact care that they need and where the person's at. And then you have a family that comes in and says, can you quickly just print this document and get Dad to sign because we want to sell his car, or we want to sell his shares, or we want to change a trustee. And I look at the document and I go, I can't. You get faced with all these, can you quickly get Dad to sign? And the mental score, like Dad doesn't even know what's happening. Like how can you advise us to help us and support us on situations like that? Because then you're stuck with the family and you're protecting the resident, but you know that the person cannot sign for themselves because you know the Mental Health Act, which is what governs me, and I work according to the Mental Health Act, and I can see the family's point of view, because before Dad became mentally incapacitated, he was a trustee and he was aware of this and this, but dynamics change. But they didn't change with the dynamics, and now you're stuck with the problem.
Well, I suppose one thing that could be helpful there from your point of view as an institution is, and you may have something like this already, is just to have a 1 or 2 page policy document, just setting out briefly what you are entitled to do and not entitled to do, that you can actually show people who ask you that. One of the things would be, that you have no power to sign documents on behalf of somebody who lacks mental capacity. And just have that kind of policy statement ready that you can show people. That might be something that could be useful to do if you don't have something like that already. And the other thing is, I'm just thinking aloud here, but it may be useful if there is some urgency or if there's a sort of dramatic situation going on to try to get that simpler administration appointment in terms of Section 60 of the Mental Health Act, even if a curatorship is necessary as down the line, because it might just be simpler and quicker to get the administrator appointed and then proceed with the main curatorship if it's necessary.
Can we as an institution then start that process?
You can,
or do we need someone? Can we then approach the court and say we think there's foul play happening and would someone come and investigate? Or whose responsibility was it?
It's an application to the Master's Office. It doesn't go via the court, it goes to the Master's Office, but it does have checks and balances built into it. So you also need medical reports. You will need it to be supported by a family member. And the Master, if the estate is valued at more than £200,000, more than £24,000 a year income, will then initiate an investigation just to check that it's an appropriate case. But particularly for poorer patients where there is an urgency, it might be a procedure worth considering, which you can then get the doctor's reports together, and the forms are relatively easy to fill in, and obviously people like Gunnar and I can help to get it into the Master's Office, but it is something that can largely be put together by yourselves or the family.
Thank you.
I think we might have approached this topic already. Accountability to curators. That's the very next.
Yes, I think we did cover that. I mean, there are 2 sides to it. The one is that curators and administrators have to keep very detailed records. As I said, everything that comes in, everything that gets spent. But also there seems to be an angle to that question of your own accountability to curators that you work with. And similarly there, just keep, as I'm sure you do, just, keep records of everything that happens, particularly where an invoice is involved, so that if you quarterly get together with the curator or monthly or whatever, then everything's easily accessible. And it's probably a good idea to talk to the curator or administrator about how you structure your file, because if your filing is similar, it just makes everybody's life a whole lot easier.
Yes, and I've also found when it comes to medical care and prosthesis, or whether it's a simple thing like a hearing aid or a wheelchair, just the more motivations and submitting quotes and things like that, just keeping everything together in a file, like you say, because you'll be amazed 6 months after a resident has passed away. I have a resident that passed away in March or April this year, and only now the curators are coming back to me saying, hey, do you remember that thing? And then if you don't have everything in the file with all the costs and all your motivations, you really are lost. So it's very important to keep a written paper trail of everything.
And then
Something
finally,
I've also learned is, especially with those residents who don't have family. Sorry,
no, go ahead.
Marseille?
Yes, sure, go ahead. Yes.
Especially with those residents who don't have other family members close by, is that the curators is almost like their family. So anything we want to do with or out or has to go via the curator. We can't just act on our own, and we have to be transparent and get permission from the curators. And I think ultimately we have to collaborate with them in the interest of the resident, because that's what we are here to promote and to maintain.
Okay, and finally then, laws protecting the elderly with regards to finance. I think we also might have touched on this topic.
Yes, I think we have. Basically, we're just governed by the Elderly Abuse Act. That's number one for us, and safeguarding the resident in all aspects. So it's horrible to put these multiple hats on, because you want to be a trusting person as a caregiver, but just to take cognizance of just the potential, especially if the person is a wealthy person and they have large sums of money in their bank accounts, and like I was saying, things like bank cards, safety of ID books, passports, SASSA pension cards, all of that kind of thing, just to keep a close eye on it and a close record of what they came in with and where the items are going to, personal property wise as well. Yeah, and so often it's easy for a family to come in and say, hey, I'm just taking this and this out of mom's cupboard album, just changing the SIM card and bringing it back, but you don't know what they're doing with that person's information. It's quite an awesome responsibility. We've just had a case like that recently where a resident's cell phone went out, and then the family changed the SIM card, so they've now got access, and then they return the phone to you with different SIM cards in, and you've just got to really have a heightened awareness of what's going on, like under your nose. Yeah, because there's a lot of sly people. Yeah, just got to be aware. Just to do your best.
I think Letitia's connection's a bit. Go ahead, Letitia. I think we're back. Can you hear?
No, I said I'm fine now, thanks.
Okay. Okay, we have a couple of Q&As that have come through. First one, does the power of attorney need to be a lawyer?
No, it does not. It's called a power of attorney because I presume it would frequently be in favour of a lawyer. But you can give a power of attorney. I think John mentioned this at the beginning. You can give a power of attorney to anybody that you would like to give a power of attorney to. It obviously should be somebody that you trust. Ideally, it might be a family member. Perhaps the family member should be younger than you, and where the probability is that he or she can do things that you might at some stage struggle to do. To go and stand next to you at the licensing department to get your motorbike, to get your car license renewed. Give a power of attorney to your 40-year-old child rather than the 70-year-old parent having to stand there for 3 hours. That's where a power of attorney really comes in. And don't give it to a lawyer, because he's going to charge you for standing for 3 hours in the queue.
And I think many of these Q&As are really just to sum up what the conversation has been about. So the next one really then, in summary, when is power of attorney useful? In summary.
Yeah, so I think pretty much covered earlier, but just to say that rather have it than don't have it. Yes. Just because situations will crop up, like Gunnar says, licensing and things like that, or collecting documents at a courier who won't accept just a letter. Just little practical things like that. Rather have one than don't have one. It just comes in useful.
At the same time, don't overemphasize what a power of attorney can do. Because as John mentioned right at the beginning, keep in mind that a power of attorney is that you sign outside a bank is not going to be useful for bank things. And also keep in mind that, strictly speaking, a power of attorney, you can only give away as much power as you yourself have. And if you have lost your power to transact due to mental incapacity, you can't give away power that you don't have. So really it comes to an end then. Some people will continue using it for minor things, and if no harm is done, then no harm is done. But strictly speaking, if I go and sign a document because somebody's given me a power of attorney, but that person no longer has capacity, then my signature on that document does not count for anything.
Yeah, I must admit, when we deal with residents coming into the villa and in the admission process, and I'm presented with a power of attorney to sign, I just tell them outright, sorry, it's not valid. Yeah.
Okay, and finally then, once again, in summary, what are the different types of power of attorney, quickly?
I think once again, John mentioned that we often deal with what is called a general power of attorney. That's a 3 or 4 page document that's been developed by lawyers over 200 years, and it deals with every conceivable event. So the idea is that if you give somebody a general power of attorney, they can hire and fire servants, they can go and deal with licenses, they can go and buy property and sell property on your behalf. So it deals with every conceivable event. And then you have a special power of attorney that is linked mostly to a specific transaction. So perhaps most people will have experienced a power of attorney that they've signed in favor of a conveyancer to deal with a specific property transaction. So if you have sold a property and you instruct your conveyancers to transfer it to the seller, they will ask for a special power of attorney which will enable them to appear at the Register of Deeds and transfer the property. And the power of attorney does not go beyond that. So they can't deal with anything other than the transfer of that specific property. That's called a special power of attorney. So you have the general and the special. That's overseas. In some jurisdictions, you also have the so-called enduring power of attorney that can last beyond incapacity. We don't have that here.
Letitia, do you want to mention what the two of us did the other day, or do you want me to?
Yeah, I actually wanted to close. I just want to say that people often think of attorneys and curators, no offense, John and Gunnar, as cold or uncaring people or persons. And we actually had a good, it's a very interesting experience last week. One of our residents, who is one of your clients, or a curator, who you are curating, we were informed that her house was being sold, and what happened, she came to us after she fell and had a hip fracture, and she just never went home. So her house is left as the day about a year ago. And we just thought, shame, the house being sold now, and the curators are going to pick up and clean up and sell whatever's necessary. And we thought maybe we could go and look for some memorabilia for her, for things that may be important. And we approached the curators, and they were very helpful and friendly, and they opened up for us. They gave us time to go through the house. It was a very difficult experience for us. Obviously, we didn't know what to take, what not to take. The house has been standing for a year or so, but they were most patient, and even now we're in communication with them. And so, just to vouch that attorneys and curators are not cold and feelingless people. They also care, because I think they have the interests of their resident or patient at heart as well. And if we collaborate correctly with them, we can really make miracles happen and make a big difference in people's lives. So it was a humbling, sad experience, but it's
awesome. It was awesome. The things we brought back absolutely jarred her memory, and it was just, even though it was sad for us, we were literally, Letitia and I, standing in the house, and the emotion was just really overpowering, because you're like, where to start? But you can absolutely see the person you're caring for in the house, and you can see their personality and just how the passion of them is in the house, and we just didn't have enough hands to take everything we knew that could help her. So we took the important stuff, and luckily the things we chose helped her, and we're so grateful that we actually did that to help her. It was a very emotional experience, but the quality of life was this lady is now thriving with the stuff that we brought back that's now in her room. It was actually a very sad but nice experience.
That's good news. I think that my colleague who attended this mentioned it to me. I think the house had been empty for literally a year or more, and when the door was opened, the cat walked out. Is that the same?
Yes. The kitty litter is still in the bathroom from more than a year ago, and it's literally like she left the house the morning, and it looks like still notice list all over. So thank you for that opportunity. I think that makes a difference. You can have partnerships like that.
Okay, and then in closing, final words of perhaps advice, or we can go around the square rectangle really on our screens, and maybe anybody wants to say final words in closing.
I just want to say from my point of view that it's imperative, whether you're dealing with family that have power of attorney or curators, it's just to have such a close relationship with these people, and it's so important to communicate absolutely everything and absolutely record keeping. It's so easy to get caught in the rut of saying, oh, we'll do it next week, but really, as things happen, it's so important to make notes and keep files updated, and and relationships. You work so closely with people with power of attorney and curators, especially in a unit where you're dealing with people that are mentally incapacitated. So communication and relationships and team building is absolutely vital. That's one of the lessons I've learned. Yeah. They're literally like if you're the left hand, you're literally my right hand, and I can't do it without you, and vice versa. So I just want to thank you for your support.
Very much. I also think we've learned that we have responsibility as clinical personnel on the floor to look after the clinical needs and the quality of life needs, but we also have the responsibility to report back to the curators and to make sure that there's absolute transparency all the time, and that we will report if there's anything that I think is not supposed to be happening, and that we can give the information to the right people. So we have the responsibility to take care of the resident in more than one way. And thank you guys again for supporting us so well.
It's a great pleasure, and thanks for the conversation and the opportunity. And I suppose the only useful thing to say in summary from my side, closing, is if somebody has something on their mind or a question about what to do, act on it. Speak to somebody, make a call, ask the question, rather act earlier than wait until it becomes more difficult to sort out. But thank you very much. It's been great.
Yes, thank you. I think it's been a useful discussion for possibly some of the relatives and children of elderly people that you look after. When I deal with people like that, one of the questions that is more often than not asked, and rightfully asked, and it just hasn't come up today for some strange reason. So perhaps I should just try and answer it in case it's in somebody's head. What does a curatorship cost? Now, John mentioned earlier that there is a cost of the application. 40,000 to 60,000 rand is probably the sort of ballpark. But then, of course, the curator may for many, many years look after the patient's financial affairs. How is that remunerated? And I might just perhaps very briefly mention that it's not really a paying proposition for any attorney. The actual, there's not generally any sort of real profit in it. It's one of the things that we do because we do it. It's strictly regulated. It's 6% per annum on income. So if your patient, your resident has 2 million rand in the bank and earns 300,000 rand or 200,000 rand, it's very unlikely with 2 million rand in the bank, but assuming that there's 4 million rand in the bank and there's income of, say, 400,000 per annum, the curator is entitled to 6% of the 400,000. So it's only on income. It doesn't reduce the capital at all. So it's a very moderate amount. It's something that it's not really a paying proposition. On termination of the curatorship, the curator has to file a final account and then hand over whatever is left to the patient's executor, and he's then entitled to 2% on capital. So that can sometimes, depending on the size of the estate, make the thing have been sort of marginally worthwhile, but it's not really something that attorneys do to make money. It's contrary to popular belief. That's not what it's all about. And that's it.
Thank you.
Wonderful.
Okay.
Thank you, John O'Leary and Gunnar Dahl, for participating in this amazing workshop. We truly hope it was beneficial to all of our family and friends of Nazareth Care Africa. Please watch and view and like our Facebook page for any further updates on our next online workshop, which we will hold on the 21st of January. Another exciting topic of taking the next steps when it comes to senior living. Again, for more information on Nazareth Care Africa and the ways in which you are able to get involved as a family and friend of Nazareth Care and the general public, you may contact us and send us an email on connect@nazarethcare.co.za, and we look forward to hearing from you all. Good night, everyone.
Good night.
Good night.
Good night. Okay, thank you guys. Thanks everybody. Lovely. Wonderful.
Have a nice evening.
Nice. Bye-bye.
You too, Anna.
Cheers. Bye. Lovely, thank you, Melody. Very nice. Very lovely. I saw Gunnar with his sneaky wine. Gunnar with his sneaky wine.
Stop drinking wine.
It's obvious, yeah.
I didn't see it. Did that really well.